The claim of the appellant is that as he had been declared as medically invalid prior to his date of superannuation, therefore, instead of issuing retirement order on the basis of superannuation, the same should have been issued on medical grounds, full stop. It is observed that for retirement of the appellant on medical ground basis, order to that effect by the competent authority was required to be passed by application of mind to the facts and circumstances of the case, which order had not been passed till the date of superannuation, as the report of medical superintendent to provide information of countersign slash confirming it by Director General, Health Services was awaited. Full stop. The request of civil servant for recall of his retirement order on medical grounds after its issuance was not entertained by the Supreme Court by treating the same as having attained finality, being a past and closed transaction, despite the ground raised by the civil servant that he had withdrawn his request for such retirement one day prior to passing of order of his retirement, which ground was not found to be correct. Full stop. By the said time, the competent authority had also become functus officio. Full stop. In these circumstances, retirement order with retrospective effect could not be passed on the basis of medical invalidation when the appellant earlier stood retired on the basis of superannuation. Full stop. For what has been discussed above, no ground to interfere in the order passed by the learned single judge in chambers is made out. Full stop. Resultantly, this appeal being devoid of any merit stands dismissed. Full stop.